Hello, everybody, and welcome to the Aspen Author Webinar Series. Today's topic is What's New in Property. But before we begin, I have a few housekeeping items for us to review. First off, the audio for this webcast is through your internet only. I highly recommend that you use a headset or earbuds or listen to this presentation through your laptop or mobile speakers. Secondly, this is a one-way communication. You can hear us, but we cannot hear you. So if you have any questions, please use the chat feature. And now I will hand it over to Joanne to introduce today's presenters.
Thank you, Allison. Hey, everyone. Thanks so much for joining us today. I'm Joanne Butler. I'm the managing editor for the doctrinal list at Aspen Publishing. And I have the great good fortune to be able to work with some amazing legal scholars to develop learning resources for first-year law students. It's my honor to introduce you to the authors of the recently released 10th edition of Duke Manier's Property and our presenters today. Gregory Alexander graduated from Northwestern University Law School and then clerked for George Edwards on the U.S. Court of Appeals for the Sixth Circuit. He spent a year as a Bigelow Fellow at the University of Chicago Law School and then served as a professor at the University of Georgia School of Law. He then moved to Cornell, where he was the A. Robert Knoll Professor until his retirement in 2019. Professor Alexander has been a fellow at the Center for Advanced Study in the Behavioral Science in Palo Alto and at the Max Planck Institute for Comparative Law in Hamburg and Heidelberg, Germany. He's taught at UCLA, Virginia, and Harvard Law Schools and was the Herbert Smith Distinguished Visiting Fellow at Cambridge University. Lior Strahilevitz received his JD from Yale Law School, where he served as executive editor of the Yale Law Journal. Following his graduation, he clerked for Judge Cynthia Holcomb Hall on the U.S. Court of Appeals for the Ninth Circuit. He then practiced law in Seattle before joining the law school faculty at University of Chicago, where he was named the inaugural Sidley Austin Professor of Law. He's two-time winner of the Law School Graduating Students Award for Teaching Excellence. And Professor Strahilevitz was elected to the American Law Institute in 2015. It's my pleasure to turn the presentation over to Professors Alexander and Strahilevitz.
Thanks so much, Joanne, and thank you to everyone who's joining us, whether you're watching live or watching the recorded version after the fact. We wanted to sort of take this opportunity to review many of the new developments in property law over the span of the last half decade or so, and also to talk about how the latest edition of the Duke Manier and Creer casebook reflects some of those recent changes. As many of you probably know, the 10th edition of the book just came out, and so we're really excited about the timing. There was so many interesting legal developments in 2020, 2021 that we were able to talk about in the book, and that if you use the book either as your primary teaching material or as a reference, you'll be able to consult a version of the materials that's right up to date. So I think without further ado, I'll start talking about some of the most important changes in the book, then I'll hand things off to Greg to consider sort of more interesting developments in property law, all of which will be reflected in the most recent edition of Duke Manier and Creer. So one of the things that was really important to us as we thought about transitioning to the latest volume of the casebook was a heightened interest in anti-discrimination law among ourselves, but most pertinently among our students. In teaching materials over the years, I've certainly found that students are most engaged on these topics, or especially engaged on these topics. And so we really wanted to bulk up the way in which we talked about anti-discrimination law. And that's something that shows up in the landlord-tenant chapter, but it also shows up in the chapters on covenants and common interest communities and really throughout the book. One of the cases that I was most excited to spotlight reflects a really recent and important circuit split. And so in the 10th edition, we've added a Seventh Circuit case called Wetzel versus Glen St. Andrew. And Wetzel, as well as its companion case out of the Second Circuit, which is Francis versus Kings Manor, decided in 2021, present the same issue, and the two courts come out quite differently. The issue is essentially this: under what circumstances might a landlord be responsible for unlawful discrimination by one tenant committed against another? So in the Wetzel case, Ms. Wetzel was harassed in a senior living community on the basis of her sexual orientation. The managers of the property found out about it, knew about it, did very little to stop it, indeed may have even retaliated against her when she complained about being harassed because she was a lesbian. And the Seventh Circuit, my colleague Diane Wood, wrote a really interesting opinion holding that the landlord ultimately could be responsible, even though it wasn't the landlord's agents who were engaged in harassment. As I said, the Second Circuit en banc confronted a very similar issue in 2021. The only significant difference, at least on my read, between Francis and Wetzel was that Francis involves racial discrimination as opposed to discrimination on the basis of sexual orientation. Otherwise, the facts are quite similar. And the Second Circuit really parted ways with the Seventh Circuit. The court actually split 7-5. There's a really good dissent, a really interesting majority opinion that engages in these issues. And nominally, the court distinguishes Wetzel and says that it thinks the landlord in Wetzel had greater control over the common areas of the premises where the harassment occurred than was the case for Kings Park Manor, the defendant in Francis. But the court's engaged in arguments about the purpose of the Fair Housing Act, the pragmatic consequences of imposing liability, how imposing liability could increase the incentives of landlords to screen and so on, screen tenants and so on and so forth. So there's a really interesting and I think rich circuit split. I imagine this issue will go up to the court before too long. And comparing and contrasting the two cases, I think will have a lot of pedagogical benefit. Of course, maybe the biggest change in property law over the last 5 years is the Supreme Court's 2021 opinion in a case called Cedar Point Nursery versus Hassid. And I imagine everyone on the call has at least heard something about Cedar Point Nursery, so I won't belabor the details. But what the Supreme Court does in Cedar Point Nursery is it substantially deviates from what the court had said in an earlier physical takings case called Loretto. So the kind of default set of legal rules that arise when someone alleges an unconstitutional taking are established by the Supreme Court's decision in the Penn Central case back in 1978, and the Tahoe Sierra case, which is, of course, also in the case book, kind of in 2002, sort of reiterates the idea that almost everything in regulatory takings should be resolved under Penn Central. But the Loretto case, which followed Penn Central by just a few years, establishes probably the most important exception to the dominance of Penn Central, which is when the government permanently engages in a physical occupation of land, then that's a per se taking. You don't balance, you just award compensation. And of course, what the court does in Cedar Point is it very radically expands the domain of per se tests to include not just permanent occupations, but also temporary entries, either by the government or, as was the case in Cedar Point Nursery, third parties whose presence is authorized by the government. Cedar Point involves union organizers who are entering onto a private farm for the purposes of communicating with farm workers, and a California regulation authorizes their presence there. So obviously, we're going to include Cedar Point in the casebook. Every new property book will. But to my mind, at least, the changes in Cedar Point doctrinally were substantial enough to warrant a reorganization of the casebook, or at least the chapter of the casebook dealing with the takings clause. And by that, I mean the following. Through the first 9 editions of the casebook, we had always thought to organize the cases conceptually. First, let's talk about physical takings, and then let's move to regulatory takings. So Loretto comes before Penn Central, even though chronologically Penn Central arose first. I think after Cedar Point Nursery, we can no longer do that, or at least we can no longer do that in a way that will make takings doctrine as coherent for brand new law students as it once was. And so we really shifted the orientation and the way we present the materials away from conceptual categories. After all, those categories are breaking down by dint of Cedar Point Nursery, and towards a strictly chronological presentation that really is going to allow students, if they are using the book, to gain a fuller understanding of how the Supreme Court, in a kind of common law constitutionalist fashion, develops new doctrines, expands them, contracts them, and the sort of push and pull over time that we'll see in the chapter, I think, will be a little bit easier for students to grasp than the approach that we've historically used. Another reason we need to sort of redo the way we've been thinking about the categories is that another big move in Cedar Point Nursery is to elevate the exactions cases, that's Nolan and Dolan and Kuntz primarily, and to apply them to a new set of government actions, government inspections, safety inspections, health inspections, and the like. And previous editions of the book would have taught the exactions cases after Cedar Point Nursery, but we felt that didn't really make sense. And so introducing students to exactions first, and then building up to Cedar Point Nursery as the sort of final class you'll likely teach in property, we think made a lot of sense. Even since Cedar Point Nursery came out, there's been a lot of great scholarship and a lot of good thinking. One of the reasons I think Cedar Point Nursery will be such a nice place to end your course, if that is in fact the last class you teach, is that in the month since it was handed down, I think legal scholars have identified several rather grave errors that the lawyers for California made. I think, for example, that there was a really strong statute of limitations defense that California's lawyers should have made and failed to make once the lawyers for the plaintiffs pivoted to a per se takings theory. And we talk about all this stuff in the teacher's manual for Cedar Point Nursery, and I'm going to have a co-authored piece on Cedar Point Nursery hitting SSRN in a couple of weeks that'll really work through some of the legal blunders in Cedar Point Nursery and how those blunders really ought to shape the way we think about the implications of the case going forward. So if you're interested in teaching Cedar Point Nursery, there's a lot of good stuff in the teacher's manual and a lot of great scholarship that I think lends itself to the final thought for students of, hey, maybe if the lawyers for California had learned property law a little bit better and had understood all the different permutations of taking doctrines a little more clearly, maybe this case never makes it to the Supreme Court, which is my hypothesis at least, and something I'll look forward to exploring with my students in class when I teach Cedar Point. And then just very quickly, the other thing that we've really tried to do is leverage important developments in the world and use property lens as a way to use property law as a lens through which to understand some of those developments. So obviously COVID-19 has radically transformed so much of American society, but it's presented all kinds of really interesting and important legal issues for courts, legislators, and administrative bureaucracies. And so the latest edition of the book gives a lot of attention to all the different ways in which the law has changed. We provide extensive coverage of the eviction moratoria that ultimately was largely struck down by the Supreme Court at the federal level, but which were largely upheld when eviction moratorias were enacted at the state or city level. We talk a lot about statutory developments to provide for COVID-related relief for mortgage payments. And as many of you know, there have been a huge host of really interesting takings cases brought against governments that imposed temporary business closure orders in the first few months of the pandemic. And there's so many really interesting issues to talk about with your students with respect to this takings litigation. Of course, it's a nice opportunity to remind your students of the historic police power cases. It's a nice way to talk about Tahoe Sierra and temporary restrictions on the use of land that are not permanent and how the law might treat them. Cedar Point Nursery, of course, reshuffles the deck with respect to some of those issues. But there's also really interesting questions of just compensation that arise out of some of these cases. So if these business closure mandates are in fact takings, and courts have generally been resistant to that legal conclusion, but if these are takings, then I think the just compensation questions would be quite hard, because after all, if a business closes during the early stages of the pandemic, some of that may be due to a government shutdown order. Some of that may be due to the pandemic itself. Those jurisdictions that didn't impose business closures for restaurants and bars and the likes saw business revenues at those establishments plummet, nonetheless, because people were staying away in order to keep safe. And so we leverage some of the neat empirical work that's been done in economics that tries to leverage some of the differences and make progress on the question of which business harms resulting from COVID are squarely placed on the shoulders of government, and which kinds of harms are by no means the government's fault, such that no compensation is required under the Constitution. And then lastly, and then I'll hand things over to Greg. We talk in the casebook about some really interesting litigation in the last few years that's emerged in the wake of Hurricane Harvey. Obviously, we've been thinking about hurricanes lately and the devastating hurricanes that have hit Puerto Rico and Florida. In Hurricane Harvey, there were really interesting issues that arose when the Army Corps of Engineers had to make vexing decisions about whether to release water from a dam that was under substantial strain as a result of heavy downpours. If they released water from the dam, it would save upstream neighborhoods, but likely flood downstream neighborhoods. And so it's kind of a trolley problem presented to these managers at the Army Corps of Engineers. And there's been a really interesting division in the case law. These cases have mostly been litigated so far in the Federal Court of Claims, with some judges imposing liability on the Army Corps for the damage that they did, and other decisions suggesting that the government's not liable, because after all, one set of communities was going to have to be flooded as a result of the Army Corps of Engineers, of the act of God, and the Army Corps of Engineers was just trying to do the least harm possible. We also draw connections in this material to the Conflagration Rule, which some courts have linked up to in discussing these Hurricane Harvey flooding situations. Some courts have ignored. We suggest that maybe the rule for fires spreading out of control and flooding spreading out of control ought to be symmetrical, but maybe not. And that'll be a fun issue to discuss in classes that cover these issues as well. So I'm going to pause for a little bit and hand things over to Greg.
All right, thanks, Lior. Afternoon, everybody. Good to see you all, or not see you, as the case may be. So there actually is quite a bit of new material in this edition, including in the chapters for which I'm primarily responsible. One of the really interesting and I think exciting cases, exciting for students as well as the teachers, is a case out of Virginia with which your students may be familiar, Taylor versus Northam. This is the Robert E. Lee statue case involving the, let's say, well-known monumental statue of Robert E. Lee standing in the row of Confederate generals in Richmond, Virginia, over which there was a great deal of discussion about whether or not to leave it or remove it. The governor finally deciding to remove it, and the heirs of the donor attempted to block that. The court decided that it could be removed. The governor was within his rights to remove it, despite a clause in a covenant in the original deed transferring the land on which the monument stands, restricting the use of the land to the monument and the statue for Lee in perpetuity. The basis for the decision will be an interesting issue for you and your students to discuss. It seems to be government speech, that is, the court deciding that the restrictive covenant is unenforceable because it's unreasonable, and it's unreasonable because it compels the government to contract away a power that it cannot contract away, and that is its power of communicating government speech. But there is also discussion scattered throughout the opinion about change conditions. The deed was executed in the late 19th century, 1887. And there's a fair amount of discussion in there about how circumstances have changed, particularly with respect to attitudes towards Lee and what the statute represents. So we posed the question in the notes afterwards, is this in fact a change conditions case? So that's why the case is located in the section on restrictive covenants on the change conditions doctrine. Another interesting case involves amenity discrimination in common interest communities, Curto versus a country place condo association. This case involves discrimination, alleged discrimination, both on the basis of gender and on the basis of religion. Amenities were provided in this condo association, particularly swimming, and there was an allegation that the amenities, the swimming hours, were skewed in such a way that it was discriminatory against Orthodox Jews. A schedule was placed on the bulletin board of the condo, and the schedule appeared to be appeared at least to those residents who where the plaintiffs appeared to be discriminatory against Orthodox Jews and against women in particular. The court had to determine whether or not there was, in fact, discrimination on the basis of segregation on the basis of both gender and or religion. Another case that I think is immensely fun to teach is a aesthetic zoning case. This is a new aesthetic zoning case called Burns versus Town of Palm Beach, in which a very wealthy person who lived in Palm Beach sought a building permit to put up a very different kind of building or house, different from the type of architecture that his neighbors had, but he insisted on his right to do that and also argue that it really would fit in. And more importantly, he said that the architecture expressed his views, his ideas about the proper way to live. So he argued that the aesthetic zoning regulation, which prevented him from going ahead with his plans, violated his First Amendment right. And the court is split. The Court of Appeals is split over this. The majority holding that there's no First Amendment violation here, but there's a very vigorous dissenting opinion that goes on, and I've had to radically edit the dissenting opinion, but it vigorously argues in favor of First Amendment rights of this landowner. There are also new materials in the book on, there's a recent material on reverse redlining in Atlanta. There's new material on the Homeowner Equity Protection Act, statutes involving removal of racially restrictive covenants, the RLUIPA statute, and also on recent moves to eliminate single-family residential zoning. All of this material is in textual notes. So there's a fair amount of new material in the book that really, I think, makes it much more interesting for these students. So, question about what might be trimmed if you're teaching a short property course, as I'm sure at least a number of you are, a 4-course, maybe even a 3-hour course. What can you skip? Lior suggests that maybe parts of chapter 3 that introduce intellectual property could be skipped. I'm responsible for chapters 4 and 5 on possessory estates and future interests. You know, back in the old days, I would have said that it was heresy not to teach that. I no longer take that line. For one thing, students no longer view it as relevant. If they ever did view it as relevant to their concerns, they really don't do it at all today. And to the extent to which it is covered on the bar exam, increasingly less today. They can pick it up on the bar review course. So, and boy, the students just really resist this stuff. So you might just skip it or really give it a lick and a promise. You certainly can skip marital property. I think most of you do skip that anyway. You can skip land transactions because virtually every law school does offer an upper level course on land transactions. But again, many of you already do that. Zoning, that can be skipped for the same reason. There are upper level courses, but again, many of you already skip that. On the takings chapter, I'm going to let Lior talk about what he thinks might be skipped or shortened in coverage.
Yeah, there are some instructors who don't cover takings. I think that's hard to do, especially given the composition of the current Supreme Court. And I think Cedar Point indicates that this court is likely to use the takings clause much more aggressively than its predecessor courts did. So if you decided that you did want to cover takings, but do so in a way that just takes, let's say, a week of class time versus 2 weeks, then I think covering Kilo plus Penn Central plus Lucas, probably Tahoe Sierra, and certainly Cedar Point would be the way to go. And I think one thing that that I'm planning on doing when I teach property in the winter course is leverage another sort of brand new product that the two of us just put together over the last year or so with Molly Brady. So Molly and us have written something called Practice Perfect. And what I intend to do is assign some Practice Perfect modules as a supplement where I don't want students to necessarily get slammed with too much reading, but I do want certain concepts to get covered. So let me tell you a little bit about what Practice Perfect is. And there's I think Joanne just dropped the link to it in the website for those of you who are interested in getting a professor's review copy. You can certainly do that. You can think of Practice Perfect as kind of a learning tool that's aimed towards students who are visual and auditory learners. And so Molly and Greg and I have basically divided the property course up into 40 modules. So there's a module covering the rule against perpetuities. There's a module covering exactions. There's a module covering lost and found property and the like. Think of each module as maybe one class session if you were teaching 40 classes of property. For each module, we the three of us wrote like a 10 to 12 minute video, and then Aspen's video production team animates our video text. And so you see really nice graphic illustrations of key concepts. And for some of the material, I think the visuals are really captivating in ways that neither text nor the spoken word alone can be. And then after your students see these 10 or 12 minute animated videos introducing a concept, they will take a quiz, a multiple choice quiz, typically 10 questions, and then Practice Perfect will automatically grade their answers immediately, explain all the different answers to the questions they got wrong, and Practice Perfect bundles in kind of a multiple choice exam that they can take as a midterm review or as sort of in preparation for the final exam. And there too, we've written, sort of several lengthy exams covering the whole course where they'll get automatic grading, they'll get immediate feedback about where they want to stray, And for me, at least, who tends to teach a really large enrollment property course, it's going to be really nice to allow students to get immediate feedback and identify areas where their subject matter knowledge may need improvement without me having to grade, multiple midterms or try to track down teachers' assistants who can give them all the feedback, which will be so helpful to them. So, one thing I'm planning to do in the winter when I am teaching the course is, for example, for exactions, I'll simply ask my students to view the exactions module rather than reading the Kuntz case, for example. And if there's material that you really want to cover, but you're squeezed because you've only got 3 or 4 credits, then one thing you might think about is that strategy of integrating Practice Perfect and using it as a supplementary teaching tool to either, the Duke Minier Classic Edition, the Duke Minier Concise Edition, or really any other great property book out there, Smith and Merrill and Brady, or the Singer et al. Book, or the Sprankling book. There's obviously a lot of great books in the market, and Practice Perfect is designed to work with any of them. So I think at that point, we're kind of done talking at you and are looking forward to answering questions. It looks like several have already been posted in the chat, and so we can sort of start talking about those.
Wonderful. Thank you so much for your presentation. We have entered the Q&A portion of today. So if you have any questions, please use the chat feature and I will read them out loud. And it seems like we already have a few kind of straggling in. So why don't we get started? First off, will there be a new edition of the concise version of the book that reflects some of the changes you are discussing?
Yeah, so the first 2 questions relate to the concise edition. So I'm going to take those 2 questions together, if you don't mind, and I'm going to answer those 2 questions because I am primarily responsible for the concise edition, although Lior certainly helps me on that. I believe I am due to turn to the concise edition in 2 years. If Joanne is around, she can correct me on that, or Lior, maybe you could correct me, but I believe the concise edition is, there's a lag between the concise edition and the classic edition by 1 year. So I will be doing the concise edition 1 year before the next edition of the classic edition. Do I have that right, Lior?
Yes, I think that's right. And Joanne's chiming in and mentioning late 2024 is the likely publication date for the concise edition.
Yeah, right. Publication in late 2024.
I will say, Greg, for people who've adopted the concise edition, but for example, really want a version of a new case that postdates the concise edition's publication, we're always open to sharing edited versions of those cases. So if we can help you with a up-to-date version of Cedar Point Nursery, or of the new case involving the Robert E. Lee statue, that's certainly something that we like to do so that your class can be up to date in that lag period between editions.
Right. Anybody who is using the concise edition but would like any of these new cases that are that appear in the classic new 10th edition but not in the concise, please just contact Lior or me and we'll get those new cases to you. When I'm doing the new concise edition, I will absolutely put those new cases and the other textual material in the new edition of the Concise.
Great. Next question is, does Practice Perfect supplement or replace connected quizzing for you? And I don't know if either.
Yeah, sorry. You know, I'd be. I don't actually know for sure the answer, but I regard it as more of a replacement where you probably wouldn't want to use both of them. And we like to think of Practice Perfect as sort of the state-of-the-art model, because it does include the audiovisual material alongside the questions and answers, the multiple choice with immediate grading. So I think this is Joanne's department, so she may supplement what I say, but I think most instructors who have been using connected quizzing may very well decide that it makes sense to shift over to Practice Perfect as the sort of more complete, more user-friendly model.
Yeah, we do have some folks that are doing both, that will use Practice Perfect more as, kind of self-study, tutorial, and then use connected quizzing as more of an assignment where they might grade it, for the students. So it just kind of depends on how your course is set up, what level of formative assessment you want to incorporate. It just does offer one more level of that, is what I would say, where connected quizzing is more straight up, lots of multiple choice questions. Practice Perfect has that added instructional aspect to it. So it just kind of depends upon what you think your students need most. But, we're happy to provide, as you said, Lior, we're happy to provide instructors with access to the sample materials so they can kind of evaluate that. But I would say Practice Perfect is a little more robust in terms of the way it has sort of the instructional piece with the audio visual, lots of questions, and connected quizzing is more straight up quizzing.
So I would also say that Practice Perfect is something that Lior, Molly, and I have written, but we had no involvement in writing connected quizzing. So if that matters to you, that's something to bear in mind.
Great. Would you share note material from the new edition with users of the Concise edition to distribute to students?
I'm perfectly happy to do that.
Great. We will get you in touch. Excuse me. Next question is.
I should say just that I won't be able to get that material out immediately. It'll take me at least 3 weeks because I'm leaving early tomorrow morning for a 3-week trip.
Yeah, Greg, and we can help with that. I would say for anyone using the Concise edition, the best thing to do may be to just go ahead to reach out to me or to your local representative account manager, because we can kind of coordinate the best way to provide that access and make sure you've got the materials you need in a timely fashion. We've got access to all the materials, so of course, feel free to reach out to Greg and Lior with questions you might have about how best to incorporate, which ones you might prioritize, that kind of thing. But in terms of once you kind of determine these are absolutely the materials I'd like to include, I'm happy to help, or your account rep too could help in terms of actually getting that access.
Thank you. All right, so setting aside the cases you've already mentioned, what new case are you most looking forward to teaching in this upcoming edition?
Maybe I'll take a first stab at that. I skipped over one slide because I know a number of the instructors on the call don't cover intellectual property, but I actually do, and I found the connections between intellectual property and real property and chattel property to be really wonderful and rich topics for class exploration. And a couple of cases that I haven't talked about but are brand new, both of these are 2020 Supreme Court cases, really link up nicely with the public trust. So, built into Chapter 3 is a module about inherently public property. And I think a lot of you teach concepts of the public trust, navigable waterways, beach access, and the like. Matthews versus Bayhead is I think the famous case that a lot of us have taught. But it's really interesting to explore how conceptions of inherently public property might differ when we move away from rivalrous resources like land towards relatively non-rivalrous resources like intellectual property. So two brand new cases in Chapter 3 of the book touch on these issues. The first one, Georgia versus publicresource.org, looks at whether the state of Georgia can assert copyright in the annotations of the official Georgia Code. And the Supreme Court split 5-4 on this issue, ultimately holding that they could not, with Chief Justice Roberts writing an opinion that in many ways sort of echoes some of the themes that you'll hear echoed in public trust doctrine cases about how individuals shouldn't have to pay in order to fully understand the law, that some of the dangers of privatization with respect to statutory annotations. So it's a very interesting and rich case. Similarly, or maybe as an alternative, I think some of you cover the topic of generics and trademarks and sort of some of the pro-competitive reasons why generic marks can't be protected under trademark law. And again, there's really interesting and nice connections between that idea and some of the rationales for the public trust doctrine, especially when we're talking about navigable waterways. Whether giving someone, let's say, control over the use of the word booking with respect to travel reservations, whether the generic nature of the word booking impedes competition in the same way that letting someone install a toll plaza on the Mississippi River might. And booking.com is really interesting because the court, while embracing, the longstanding doctrine that generic marks can't be owned, it holds that when you add a .com at the end of a generic term like booking, well, that can be subject to trademark rights. And so we get a really interesting discussion between the majority and the dissent in that case about consumer confusion, about incentives to invest in brands, when consumers gain, when consumers lose. And I think you can nicely draw connections if you teach that material, again, to questions like public ownership of the beachfront. On the one hand, there are nice notions of democratic access that might explain the public trust doctrine. On the other hand, there's some arguments that the public trust doctrine might create a kind of tragedy of the commons, where the beaches maybe aren't as clean, maybe aren't as pristine in a world of the public trust doctrine as they might be in a world where private owners were able to exercise monopolies over the dry sand portions of the beaches. So those are connections I like to draw. And Chapter 3 in general, for those of you who have time to cover these issues, has lots of interesting connections that it draws, where it pairs a case involving the abandonment of intellectual property with the abandonment of real property and chattel property, say, or questions involving the right to destroy, when we're talking about someone who wants to destroy a house via her will, and someone who has gotten involved in vitro fertilization, and one partner after a divorce would like to go forward with implantation, the other would not. And what are the impulses that strike judges when they're talking about destroying a house versus destroying a fertilized or unfertilized embryo. Those are sort of interesting issues that arise in the context of Moore versus UC Regents. We draw connections between patent law and the spleen ownership question in Moore with respect to important questions like, what is the nature of discovery? What is the nature of innovation and invention? Questions like, what's the proper role of legislatures and courts in deciding whether to recognize property rights that may be ambiguous in biological materials, where the moral questions associated are hard and complex, where there's ambiguity? Should a legislature or a court recognize property rights? Should they back off? And what is the dialogue between legislatures and courts over those kinds of issues look like? So there's lots of connections for those of you who are interested in exploring them in Chapter 3, and some hot off the presses Supreme Court cases you can explore.
I'll simply add that I no longer teach first-year property because I'm retired, but what I did, and I taught it up to the bitter end, I taught the material on intellectual property, not teaching the material on an extended basis, but I did teach it for 2 or 3 days, even though I had a 4-hour one-semester course. And I did it emphasizing to students the importance of understanding the connections between the general background themes that Lior has already identified and what the students are going to be seeing down the road. Lior has already highlighted those connections. And I really emphasize to the students right up front the importance of making those connections, so that when we got to, let's say, Bayhead, I asked the students to look back and remember what we had talked about previously. For those of you who teach the concise edition, you may recall that there's a little tickler reminder that's in the margin called a look back. And that has as its purpose precisely this idea of making these connections, forcing the students, let's say you're teaching Matthews, forcing the students to look back to the material on IP and recognizing that you're still talking about what you had been discussing at the beginning of the course regarding commonses and inherently public property. And I never got any sort of pushback from the students. I found that they really appreciated that, and the students had no difficulty at all understanding the material that we were covering in the material on intellectual property.
Great. So I do not see any more questions coming in, so I will hand it back over to our presenters for any final remarks. And I thank you again for your presentation.
Thanks so much. I think one of the great privileges of teaching a book that lots of people use is that we hear from our adopters, and every typo that makes its way into the book drives me crazy. But at the same time, thank you to all of you who've flagged those issues. Sometimes we get the law wrong. I've certainly been guilty of that, and we fix it in the next edition invariably, and sometimes we find out that we got the law wrong from our students, but more often we find that we could have described something better from our adopters. And so, for those of you on call who have used our book either as your primary teaching material or as a reference matter, whenever you see something in there that you think can be improved, or whenever you see something in there where you just think we're off base, please do let us know. And if you've already done that, please continue to do that, because it really does make for a better book when we can crowdsource this project. And so thanks to all of you for using the book, but also for providing that feedback.
Yeah, you have no idea how dependent we are on you for making improvements and corrections in the book.
I think that must be one of the adopters now calling with critical feedback. So thank you to whoever that person is calling, Greg.
Sorry.
Great. Thank you. Now today's webinar has ended. I thank you for attending, and I hope you have a great rest of your day.
Thanks, everyone.
Bye all.